Did you know that in 1990, the United States introduced the modern H-1B visa as a response to a rapidly changing economy that needed highly skilled workers? The goal was simple: allow U.S. companies to hire foreign professionals when domestic talent wasn't enough. Fast forward 35 years, and the H-1B visa has become a lifeline for innovation, a subject of controversy, and now a program in transition with new rules that could change everything. Today, we're going to break down everything you need to know about H-1B visas, what they are, why they exist, how they impact the economy, what the new rules mean, who's affected the most, and practical steps for anyone holding the H-1B today. So let's start with the basics. The H-1B is a non-immigrant visa that allows U.S. employers to hire foreign professionals in specialty occupations, roles that usually require at least a bachelor's degree or equivalent. This includes fields like IT, engineering, science, math, certain healthcare jobs, and academia. And in this case, employers petition on behalf of workers. The initial approval of H-1B visa usually lasts for 3 years, and it can be extended up to 6 years, sometimes more if you are pursuing a green card. The employer has to file a labor condition application and pay a prevailing wage to make sure U.S. workers aren't being undercut. So, why was it introduced in the first place? Back in the late 1980s and early 1990s, the tech and research industries were growing faster than the U.S. workforce could supply specialized talent. So in response, in 1990, the U.S. created the modern H-1B visa so companies could hire highly skilled foreign workers when there weren't enough qualified Americans. Each year, only 65,000 visas are available, plus 20,000 more for people with a U.S. master's degree. And because more people apply than there are visas, USCIS runs a lottery to pick who can apply. Some employers, like universities and nonprofit research centers, don't have this limit and can hire without entering the lottery. So let's continue talking about the numbers. Recent years have seen hundreds of thousands of registrations for a program that capped at 85,000. That shows how vital this program has become, not just for workers, but for companies that rely on highly skilled talent. And speaking about it economically, the H-1B program has had a big impact. Research shows it increases innovation and productivity, especially in tech and STEM fields. It has helped U.S. firms grow faster and compete globally. On the flip side, some studies show it can put downward pressure on wages for specific domestic workers in concentrated industries. So, while it's a net gain for the economy, the benefits and drawbacks are unevenly distributed. And here's where things get interesting. The administration recently introduced a major change, a new large annual fee, as most say, reportedly $100,000 per H-1B worker. This focuses on limiting program abuse and encouraging hiring of U.S. workers. The change could shake up industries that rely heavily on H-1B employees, especially IT consultancies, smaller companies with thin margins, and startups. Indian IT firms and other high-volume employers may be particularly affected by this, as this could dramatically increase costs. For workers, this means potential reduced hiring, job insecurity, and higher costs for employers to sponsor H-1Bs. Travel and visa stamping could also become riskier until the rule is clarified and fully implemented. So, what should H-1B holders do in the interim? Here's a practical checklist. Number 1. Confirm official guidance with USCIS and DHS to understand the formal rule and timelines. USCIS and DHS are the official sources of visa rules. News, reports, or social media posts may be incomplete or speculative, so checking the official announcements ensures you know exactly what the new requirements are, including when they take effect. Understanding formal timelines also helps you plan filing, travel, and extensions to avoid status issues. Number 2, talk to your employer and immigration counsel immediately. They control the petition process and will clarify how this fee affects you. Employers file H-1B petitions, so they ultimately determine whether and how the new fee impacts you. Immigration counsel can explain the legal and procedural implications and advise on whether the employer is required to absorb the fee or if it might affect your role or renewal. Acting quickly ensures you don't miss deadlines or face surprises with your visa status. Number 3, avoid international travel if possible until the situation stabilizes. And this is very important because changes in rules or fees can create confusion at consulates or port of entry officers, increasing the risk of visa denial or delays in re-entry. Staying in the US until the rules are clarified reduces exposure to travel-related complications. If travel is unavoidable, proper legal guidance is critical to minimize risk. Number 4, document everything. Keep copies of your I-797, I-94, pay stubs, and employer communications. Maintaining complete records of your status, employment, and petition history can protect you in case of audits, disputes, or enforcement actions. And documentation also helps your lawyer or employer respond quickly if USCIS requests information or if your role or pay changes due to the new fee. It's essentially a safety net for compliance and continuity. Number 5, consider alternatives like cap-exempt employers, remote work options, or other visa categories if your current situation is vulnerable. If your current employer cannot or will not absorb new costs, your options may be limited. Exploring cap-exempt employers like universities, nonprofits, or research institutions, or switching to visas like O1, extraordinary ability, or L1, intra-company transfer, can preserve your work authorization. Remote work from abroad may also be a temporary workaround while avoiding the US fee or travel risks. Number 6, check H-4 EAD status if you have a spouse or an H-4 employment authorization. H-4 spouses often depend on employment authorization to work legally in the US, and new H-1B rules can indirectly affect H-4 eligibility. Confirming status and any potential impact ensures your household income isn't unexpectedly disrupted. Early planning may involve expediting renewals or preparing alternatives if processing is delayed. Number 7, plan your finances in case your employer passes costs to you or roles are being cut. The announced $100,000 per worker fee could force some employers to reduce H-1B hires, cut costs, or pass some expenses to employees. Having a financial plan allows you to manage potential pay reductions, unexpected fees, or even temporary unemployment without crisis. This planning also buys time to consider alternatives like switching employers or visa categories. Number 8, stay informed. Monitor news, legal developments, and potential injunctions that could pause or modify enforcement. Because the rule is new, it may face legal challenges that temporarily halt or modify enforcement. Staying updated helps you make informed decisions on travel, petitions, or employer changes without assuming the worst-case scenario. Following credible sources ensures you react based on facts, not speculation. New fees, legal challenges, and shifting employer strategies mean both opportunity and risk coexist for workers and companies. The lesson? Understanding your status, staying informed, and taking proactive steps is not just smart, it's essential. For those navigating the H-1B system now, knowledge and preparation can make the difference between disruption and opportunity. That's all for this episode. If you are on H-1B or know someone who is, share this episode. It could save a lot of stress. Thank you for tuning in and listening to Life Skills with Jobin.